that Smartmatic developed for the May 9, 2022 elections. And if these irregularities cannot be sufficiently explained, they also prayed for COMELEC to disqualify Smartmatic from the bidding. Next. So the COMELEC and bank disqualified Smartmatic from participating in the bidding. It cited its constitutional mandate to enforce and administer all laws and regulations relative to the conduct of elections under the Constitution. Smartmatic filed a petition for certiorari with an application for the issuance of a TRO, or writ of preliminary injunction, before the Supreme Court. However, the Supreme Court did not grant the TRO, or writ of preliminary injunction. It held that Smartmatic did not have an actual, clear, and positive right for a TRO or a writ of preliminary injunction because Smartmatic was merely a prospective bidder. It also held that being disqualified, Smartmatic will not suffer any irreparable injury. So the COMELEC proceeded to conduct public bidding. The contract was awarded to a joint venture called the Miru Systems. So, in the end, the Supreme Court granted Smartmatic's petition. It held that COMELEC committed grave abuse of discretion when it disqualified Smartmatic before it had submitted any bids, without any reference to the eligibility requirements prescribed by its Bids and Awards Committee. It held that COMELEC implemented a discretionary pre-qualification regime antithetical to the Government Procurement and Reform Act. However, despite the finding of grave abuse of discretion on the part of the COMELEC, the Supreme Court did not find it sufficient to nullify the public bidding or award of the contract. It cited considerations of equity, justice, practicality, and the doctrine of operative fact. This means that the law produced consequences before it was declared unconstitutional that cannot always be ignored or disregarded. So the doctrine nullifies the law, but its effects are sustained. It is only resorted to as a matter of equity and fair play, which the Supreme Court said is present here. Okay. So that's all for my updates on jurisprudence. Now I will move on to the updates on the SPJI. Next. Okay. So the SPJI, just for a review, it is the Supreme Court's blueprint for system-wide institutional reforms aimed at delivering efficient, speedy, and equal justice. It is a 5-year plan with clear guiding principles, a work plan, and a portfolio of projects and achievable target outcomes. So what problems does the SPJI aim to address? It aims to address the perennial problems of clogged dockets, case delay, slow administrative systems, and lack of resources. Its guiding principles include timely and fair justice, transparent and accountable justice, equal and inclusive justice, and technologically adaptive management. It aims at 3 outcomes. The first is efficiency. How? Through streamlined adjudicative and administrative court systems and effective performance monitoring and evaluation. Number 2, innovation. Through the creation of an information and communications technology infrastructure for the judiciary. And 3, access. Through inclusivity, transparency, and accountability in court adjudicative and administrative systems and procedures. So some updates on the activities that we have done so far under Outcome 1, efficiency. So it has 2 objectives: to streamline court systems based on the needs of internal and external stakeholders, and to enhance quality measures to drive performance excellence. So under the first objective, we have the activity of the judiciary-wide organizational review and restructuring. So under this activity, I would like to report that the initial manual of processes for the Supreme Court is being drafted and is scheduled to be submitted to the NBank for approval next year. The second, as already mentioned by the Chief Justice earlier, is the modernization of the Office of the Court Administrator through the pilot of the Office of the Regional Court Managers, or ORCM. So a little bit about the ORCM. It aims to decentralize and improve the delivery of administrative services to the trial courts by establishing regional offices empowered to approve admin and fiscal matters and deliver multiple services directly to the courts. Before, All of these administrative processes were central to the Office of the Court Administrator located in Manila. And this proved to be quite problematic because it creates bottlenecks for these procedures. So the Supreme Court, headed by the Chief Justice, wanted to bring the administrative services closer to the regional trial courts, and they will be doing this through the ORCM. So from April to May 2024, a caravan will be conducted in 6 pilot sites to inform the judges and court personnel about the ORCM, gather feedback on current processes and inputs on possible solutions, as well as recruit personnel for the ORCM positions. So the ORCM will be officially launched in June 2024 after all the pilot sites have been conducted. So here's a schedule of the ORCM caravan. So the very first one happened in April 4, 2024 in San Fernando, La Union. The second one in April 12 in Angeles City, Pampanga. And the next ones in the next few weeks will be in Butuan City, Davao City, Metro Cebu, and Ormoc. Next slide, please. Another activity is the creation of the Supreme Court Management Committee and Planning Development Office. So the Supreme Court created the management committees composed of senior justices and heads of office. And its function is to discuss the SPJI targets. It also established an interim planning and development office tasked to monitor the SPJI projects. Objective number 2 is to launch a more inclusive and responsive health and welfare program and institutionalize a socialized health insurance system for the employees. So in April 2024, the Supreme Court approved the terms of reference for a unified HMO for the entire judiciary. In the past, the HMO was different per court. So that means the Supreme Court had a different HMO, the lower courts had a different HMO, so did the Court of Appeals and the Sentro Bayan, and so on. However, this time around, the Supreme Court justices wanted a unified one across the board, so the benefits would all be the same, regardless of which court you're from. So some features of this are same benefits across the board, socialized payment of premiums, and the judges can still avail of the benefits under this program until the age of 80 years old. Next, please. Another one is the establishment of mental health units. So the first judiciary-wide mental health summit took place last October 2023. Because of its success, regional summits will be conducted in key cities this year. As of now, there is a mental health hotline in the Supreme Court that is 24/7 and available to its court officials and personnel at any time of the day. However, in the next few months, the first mental health unit will be established in Lawag City. Next. Another activity is to pursue a campaign for ethical responsibility. We all know that the Code of Professional Responsibility and Accountability was approved last year here in Baguio as well. And because of its success, the court is now revising the Code of Judicial Conduct and the Code of Conduct for court personnel. Another activity is to operationalize the Office of the Judiciary Marshals. So an update, the draft IRR for the Office of the Judiciary Marshals is now pending approval with the court and bank. The positions for Chief Marshal and the 3 Deputy Marshals have been opened. So for Chief Marshal, there are about 48 applicants. For Deputy Marshal for Luzon, that's about 64. And for Mindanao and Visayas, around 46 or 48 applicants as well. So that's many. Right now, the applicants are currently being screened by the committee in charge. Next, please. So outcome 2, innovation. And they have the following objectives, which is to modernize court processes, strengthen ICT governance, management, and operations, and to upgrade the information sharing in the justice system. So some updates. The court is exploring using machine learning technology to develop a chatbot to aid in legal research. Workshops have been conducted and pilot users have been selected to test the system or product which is at its testing stage. Another one is the AI voice-to-text transcription system, which has been deployed in 20 select pilot courts, which includes 4 Sandigan Bayan divisions and 16 trial courts. Next. Another one is to establish a Judiciary e-library, and I would like to report that the e-Philippine Reports module has already been integrated into the e-library. So the Philippine reports can now be accessed through this website. All cases have already been uploaded. Another, which has also been completed, is to establish a Philippine Judiciary online learning platform. So the PhilJA has already established its learning management system and is being used in all of its programs. So this enables judges, judicial aspirants, and court personnel to access course materials for their professional development. Another one that is currently ongoing is the development of the e-court system version 2. So right now, the minimum viable product for the Supreme Court's e-court system is set to be launched this year. One of the important features is the digital filing feature. So that means that instead of emailing the pleadings, lawyers must log into the system and just upload their pleadings. The process mapping for the trial courts is currently being conducted this week in Baguio City Country Club in preparation for the development of e-court version 2 for the trial courts. Another activity is the revision of the rules of court. So there are many rules of court that is undergoing revision right now. One is the revised rules on criminal procedure. So the draft rules have been submitted to the court and bank, and a caravan will be conducted later this year. Some of its salient features are the removal of the rule on preliminary investigation, since this is, as the court thinks, is an executive product which belongs to the DOJ. Incorporation of special rules, such as the revised guidelines for continuous trial in criminal cases, an expanded cybercrime warrant rule, and guidelines on the video conferencing hearings, and some SC issuance on children in conflict with the law, among others. For the revised rules on civil procedure, the subcommittee is currently reviewing the proposal of its members and plans to submit its draft to the court and bank later this year. Some of its salient features include alternative dispute resolution mechanisms, which right now are available during the court proceedings, but this will be moved to pre-filing stage. So that means even before you file a case, it is a requirement for you to undergo ADR mechanisms, which I think would be a minimum of 2 ADR mechanisms before you can even file a case. The one-step appeal, which means that you can only appeal the case once and no more. So we expect that there will be less cases going up to the Supreme Court. However, Rule 65 is always available. Another is the simplified modes of review and a complete shift to electronic filing and service. Another one being revised is the rules on special proceedings, which is the committee is currently reviewing the proposals of its members. With respect to the rules on expedited procedures in first-level courts, so this rule on expedited procedures actually integrates the rules on summary procedure and small claims cases. So this took effect on April 11, 2022, and it is now in its rollout stage. Seminar and workshops are ongoing for first-level court judges as we speak. Another activity is the issuance of Book of Judicial Forms. So the revised Book of Judicial Forms was launched in November 2023. It is a compilation of templates that judges and legal practitioners may use in civil cases and special proceedings. Another is the collation and codification of SC issuances, which was also released in November 2023. It is a centralized repository of circulars, memoranda, and orders issued by the Supreme Court from 2000 up to the present. This is very helpful for everyone in the judiciary as well as practitioners, because before, the issuances of the SC were not unified in the sense that it was very hard to look for them. They weren't in a central repository, and this project aimed to remedy that situation. So, the next one under the IT objectives is to formulate the Judiciary Enterprise ICT Governance Framework. So I'd like to report that the IT Governance Framework has been approved by the Court and Bank. It aims to ensure that the court's IT strategy is aligned with the SPJI. Some of its features include risk optimization, efficient use of resources, valuation of IT services delivered, and measuring performance of the IT units. The next one is to develop a 5-year ICT strategic plan. This plan will provide the technological architecture of the court for the next 5 years. So far, a consultant has been engaged for this project. So the next one is to develop the network infrastructure for the judiciary. So currently, the halls of justice and the courts in the different halls of justice have their own internet connections, which is not centralized. So this means during the pandemic, the court allowed them to procure their own internet connections. But this project now seeks to develop a centralized network system for the entire judiciary. This would make it easier for the court or the Supreme Court to enforce its centralized policies and for interconnection and localized enterprise security. So the proof of concept was implemented in the Quezon City Hall of Justice last year. So this project is currently pending procurement for around 13 to 18 halls of justice. And lastly, we come to outcome 3, which is access. Under this outcome, there are 4 objectives, meaning enhance public access to information and legal services. Objective 2 is to strengthen legal aid initiatives. Number 3 is to strengthen the foundations of the Sharia justice. And number 4 is gender and fairness inclusivity. Next slide, please. So, the activity under Objective 1 is to develop and employ intelligent platforms for self-help, public assistance, and public access. So right now, there is a prototype chatbot for Facebook Messenger, which has been developed and is subject to the approval of the court and bank. So once this is approved, anyone who has Facebook Messenger can go to it. It's called the Judiciary Information and General Support System, and ask for 3 things. Number 1, legal aid locators. Number 2, court locators. And number 3, payment of legal fees. So this is only the initial assistance, and it will be further developed to include more assistance matters. Thank you. Next slide. Another activity is to strengthen legal aid initiatives. As we all saw from the news, the proposed Unified Legal Aid Service, or ULAS rules, has been submitted to the NBank and is now undergoing regional consultations. So the ULAS rules provides the framework for the mandatory legal aid service of lawyers. It will require covered lawyers to render at least 60 hours of pro bono legal aid service every compliance period of 3 years. One of its most important features is its expanded scope of creditable legal services. In the past, legal aid was only limited to litigation, but right now, under the ULAS rules, any legal activity will be considered a creditable legal aid service, such as drafting contracts, giving advice, development work, etc. Okay, next slide, please. So the ULAS regional consultations began last week on April 12 in the St. Louis University in Baguio City. The second one will be held tomorrow, April 18, in Xavier University in Cagayan de Oro City. And the next one will be on May 17 at the Ateneo de Manila School of Law in Makati City. And the last will be in Iloilo City, but this will be determined. Thank you. So another activity under this objective is to retool the Enhanced Justice on Wheels program. So the EJAW, or the Justice on Wheels program, it involves providing access to justice to people from far-flung areas. So it was developed in 2004 when the Supreme Court retrofitted buses to serve as mobile courts to reach the far-flung areas, aimed at declogging court dockets. Then in 2008, it was relaunched as the Enhanced Justice on Wheels program, which also offered mediation services, legal aid clinics for the underprivileged litigants in remote areas. Right now, because of the technological advancements, the court decided to retool it and called it the Remote Hearing and Equal Access to Law and Justice, or Real Justice Program. This was first inaugurated in Tawi-Tawi in February 2024. In this event, the Chief Justice was the very first Chief Justice to visit Tawi-Tawi. And it involved them bringing satellite dishes for internet connection in order to enable the Tawi-Tawi courts, especially the ones in the far-flung areas, to conduct video conferencing hearings instead of having the litigants travel more than 6 hours to the court. So, according to Senior Associate Justice Marvic M.V.F. Leonen, the features of the program includes putting these Ijaw buses in far-flung areas. Number 2, alternative forms of transportation will be used to bring technology to far-flung areas because not all places can accommodate buses. Many require transportation via sea, via air, etc. So that will be considered, as well as repurposing the buses to be used for bail purposes when courts are not in session. So when the courts are not in session, these buses will always be available in certain areas, so that persons accused will be able to file bail at any time. And we also have an activity of the review of the Sharia rules of court. There is a draft revising the Sharia rules of court, which has been submitted and is under review by the court and bank. And I would like to update everyone that the first automated and regional Sharia bar exams will be taking place on April 28 and May 2, 2024 in UP Manila and Ateneo de Davao. Okay, and lastly, regarding gender fair objectives, the Supreme Court has adopted guidelines on the use of gender fair language in the judiciary and gender fair courtroom etiquette, and this will be lectured on by Associate Justice Maria Filomena D. Singh later today. There will be issuance of guidelines for victim-sensitive courts, but this is still ongoing. And a commission to study, a commission on Philippine legal feminism study has been published last November 2023, and this was headed by Justice Filomena D. Singh as well, and supported by the GoJust. Okay, so that ends my presentation. Thank you very much for your attention.
Thank you very much, Attorney Ting. Please stay on stage as we now open the floor for the open forum. So those of you who have questions, please raise your hand or approach the microphones. So your microphone's ready. Jay. And kindly introduce yourselves and your media outlet prior to asking your questions. Thank you.
Hi, Attorney.
Hi.
Congratulations.
Thank you.
Pero ma'am, first question, sana po you could answer also in Filipino. Ma'am, may update na po ba tayo regarding the petition of Pastor Apollo Kibuloy against yung arrest order sa kanya ng Senate? And also, nanghingi din siya, I understand, ng TRO doon.
Yes, salamat po for that question. Meron na po tayong update dyan. Last April 3, 2024, on the Supreme Court and Bank's agenda, the respondents in this case, they were required to file a comment within 10 days on the petition, as well as the prayer for the issuance of the TRO and the writ of preliminary injunction. So right now, it's at that stage. We are awaiting the comment of the respondents.
Other questions? Yes, sir. Joel.
Good morning, ma'am. Joel Sanwan from Business Mirror. Regarding to sa decision sa COMELEC Smartmatic, does it mean the Smartmatic can participate na in the future bidding process of COMELEC?
Well, the case only pertains, or it limited itself only to the 2025 bidding. I mean, the bidding for the 2025 elections. So, as of now, Smartmatic can indeed, pwede po sila mag-participate in the next elections, pero subject rin to, let's say, if anyone files a disqualification case against them again.
Okay, ma'am. Thank you po.
Thanks.
Any other questions?
Yes. Lawrence Tanhoco po, Radyo Pilipinas.
Hi.
Yes, attorney. Baka may update din po tayo sa NCAP.
I'm sorry?
Sa NCAP, yes po.
Okay. Sa NCAP po, that case is still undergoing deliberations. So wala pa po tayong update doon.
Good morning, Attorney Christian po sa Radyo sa East 30.
Good morning.
Same question po kay Sir Lawrence. Update din po kung meron na doon sa final ng Piston and Manibela for the PTV franchise consolidation, I think last December.
Thank you. Same answer rin po. That case is still undergoing deliberation by the bank.
Hi, Attorney. Good morning po. Jairo Boliedo po from Rappler.
Good
Attorney,
morning.
my question is not related to pending cases, but more on the SPJI. As we know, Attorney, the court dockets are really clogged now, right now, because of like thousands of drug cases. Nabanggit na po ba or may plans na po ba tayo na napag-usapan with the ANBank on how to help our courts declog the dockets in terms of like drug cases? Meron po ba tayong nakapending na plano to specifically address this problem po? Thank you.
Right now, wala pa po that I am aware of. However, this should also be addressed by the revised rules on criminal procedure. Kasi yung rules na to, it helps makes the process, the criminal procedure, more efficient. So in doing that, it will also help declog the courts in terms of criminal drugs cases. Pero specifically for the drugs cases, I am not aware po of any initiatives for now.
Any other questions? Yes, sir.
Sir, good morning ma'am. Ben Pulta po sa Philippine News Agency. Dun sa ano po sa COMELEC ruling, may sinabi ba yung court in connection dun sa yung unique rights ng COMELEC to run elections when you contrast it with the general procurement policies of the government? I mean, may ano ba doon? Did it weigh or did it say anything about it?
Yes po. What they just said in that case was they acknowledged the power of the COMELEC. However, COMELEC itself did not comply with its own procedures sa back, and which was also, sabi nila, is antithetical to the appropriations law that applied. Yes.
Attorney Camille, just to follow up on the COMELEC case, as we know, meron po bang na-cite po yung SC if there will be like implications on the part of the COMELEC because they committed a grave abuse of discretion, although the SC noted that it ruled based on the doctrine of operative fact. But on the part of COMELEC, meron po bang parang sanction or reprimand or of any sort po?
Wala naman.
Attorney Ting, Adrian po of ABS-CBN.
Yes.
Yung doon lang po doon sa kay Pastor Quiboloy, April 3 yung order tapos within 10 days.
Yes.
Tapos na po ba yung deadline? Still iniintay pa rin po yung comment ng Senate?
Well, the 10 days will start from the receipt of the respondent of the notice. So we still have to wait for the notice to be sent out. I'll have to check if it has already been sent out by the clerk of court. And the 10 days will start from the receipt.
Thank you.
Hi po, Attorney. Luisa po, PTV4. Habol ko lang po, Attorney, any update lang po dun sa petitions filed dun sa confidential funds ni VP Sara?
Regarding that, in one of its cases, pinacomment rin yung respondents on this. So right now, it's still at the comment stage as well.
JJ Landingin, good morning,
Good morning.
of Manila Bulletin. I would like to ask if the VACC already filed an MR on the implementation of good conduct time allowance.
I'm sorry, if it filed?
MR.
MR.
Yes.
I'll have to check that, sir, and I will get back to you on that. Thank you.
Last question.
Ma'am, pwede po rin bang sa COMELEC decision, pwede din po magsabihan that SC upheld the validity ng contract ng COMELEC with Miru? Kung since it did not nullify the contract, tama po ba sabihin na it upheld the validity ng contract?
Well, I wouldn't think na it didn't directly uphold the validity because that wasn't the issue naman in the case. It just said that it will not nullify the bidding process and the awarding of the contract because of equity and practical issues and considerations. So with respect to the contract, the Supreme Court did not rule on its validity at all.
May sinabi rin po ba sa decision about anong recourse na pa pwedeng gawin ng Smartmatic since parang it was deprived of its right to participate in a election bidding process? Or
Well, the Supreme Court is of the view that Smartmatic didn't have a right since it's just a prospective bidder. Kaya po hindi na issue yung TRO or the WPI. But it also said that it did not suffer irreparable injury because the injury would have just been loss of profits. So there are legal remedies naman that Smartmatic can take.
thank you, ma'am.
Thank you.
Okay. If there are no more questions, wala na ba? Okay. Thank you so much, Attorney Ting. Wait.
One
Okay,
last.
final na talaga.
Sorry po, Attorney. Dante Amento of UNTV. Attorney, doon sa ruling po ng COMELEC, mayroon di bang, kasi binanggit ng COMELEC doon, involved din sa, ano ba yung kaso sa labas ng dating pong COMELEC chairman. Yun yung isa, Andy Bautista, na involved sa pera, ganun. Meron di bang nabanggit doon sa ruling po?
It just mentioned that that's one of the considerations the COMELEC took when it disqualified Smartmatic. But then we didn't the Supreme Court didn't delve on that.
Thank you, Attorney.
Okay, thank you for that, for answering the questions of the media, Attorney Ting.
Thank you.
The Public Information Office will now present a plaque of appreciation to Attorney Camille Sue May L. Ting, spokesperson of the Supreme Court of the Philippines. In recognition of her invaluable contribution to foster camaraderie between the Supreme Court and the members of the media, and to further the objectives of the 2024 Media Forum on Judiciary coverage by presenting in the Court's footsteps recent jurisprudence and milestones in the Strategic Plan for Judicial Innovations 2022-2027, given this 17th day of April 2024 in Baguio City. May we request Attorney Ting to please stay on stage for a while for a quick group photo with foreign participants.
May we first call on the members of the juror for a photo?